Laughed. Right there in the middle of the courtroom, with the fluorescent lights humming overhead and the court clerk still shuffling papers, my husband laughed at me. Not a quiet laugh, not even the kind that's meant to be subtle. He leaned over to his lawyer, some sharp-suited man from a firm downtown on Bay Street, and said it loud enough that I could hear it from across the aisle. She actually showed up without anyone. Can you believe that? His lawyer smiled the way people smile when they already think they've won. I set my folder on the table and sat down. 3 years earlier, I had been the one who found the house. A narrow Victorian in Westboro, the kind with the original hardwood floors that creak in exactly the right places, and a backyard that gets afternoon sun from April through October. My husband, I'll call him by what he was, which is the man I married, had wanted something newer, something out in Kanata with granite countertops and a 2-car garage. I wanted character. We compromised. We bought the Victorian. I renovated the kitchen myself over one February reading week when I was still finishing my last certification course. I tiled the backsplash on a Saturday while he watched the Senators game in the other room. I caulked the baseboards on a Sunday. On Monday, I went back to class. I was 31 when we separated. I had spent 4 years making a home out of that house and 3 years before that building a career that he had always quietly condescended to. I worked in forensic accounting, not the kind you see on television, not dramatic courtroom scenes and last-minute reveals. The real kind. Quiet. Detail-oriented. The kind of work where you sit with spreadsheets for 6 hours and find one number that is 2 cents off, and that 2 cents tells you everything. He never understood what I did. He told people I was in finance, the way you describe something vague that you don't want to explain at a dinner party. The separation came the way those things always come. Not suddenly. The way a wall develops a crack. You don't notice it for months. And then one morning, you walk past and realize it goes all the way to the ceiling and has been there for years. He told me in October, the leaves were still on the maples along our street, red and orange, and he was standing in the kitchen I had tiled with my own hands, and he said he wanted to move on. He had already spoken to a lawyer. He had, he told me, been advised. I asked about the house. He said that was something we'd work out through the proper channels. I asked about my pension contributions. We had co-mingled some financial planning, and there was a joint investment account I had been managing, largely with my own knowledge, my own time, my own expertise, that had grown considerably over 4 years. He said his lawyer would be in touch. I remember standing there after he left the kitchen looking at the subway tile I had installed myself and feeling something that wasn't quite grief. It was something colder, something that said, pay attention. I did not have a lawyer. This is the part that his lawyer and his mother and eventually his sister, who got involved in ways that were frankly inappropriate, all found very funny. His mother called my mother, which was audacious, honestly, and apparently told her I was in over my head, that I didn't understand how these things worked, that her son had retained one of the best family law firms in Ottawa, and I was, in her words, going to walk away with nothing. My mother called me afterward and asked if I needed money for a retainer. I told her I was fine. Are you sure? She said. Because Vivienne said, Mom, I said, I'm a forensic accountant. I look at numbers for a living. I will be fine. There was a pause. Okay, she said, but call me if you need anything. What his lawyer did not know, what my husband did not know, because he had never really paid attention to the specifics of what I did, was that 6 weeks before he told me he wanted a separation, I had been retained as a consultant on a file involving financial irregularities at a mid-sized construction firm. Standard work, the kind of thing I did periodically outside my regular position. The construction firm was called Harwick Development Group. My husband was a project manager at Harwick Development Group. I want to be clear about something. I did not go looking for this. I did not connect the dots immediately. When the file came across my desk, it came through a third-party legal referral, and the company name was initially redacted per standard protocol. By the time I understood what I was looking at, I had already signed a confidentiality agreement and begun preliminary analysis. I immediately disclosed the conflict to the retaining counsel. They asked me to continue. The file was time-sensitive. My conflict was documented. Waivers were signed on all sides, and I continued. What I found over the next 4 weeks was not subtle. It never is, when people think no one is looking. There were vendor payments to companies that did not appear to exist in any provincial business registry. There were change orders approved without proper authorization. There were expense reimbursements for equipment that was never delivered to any job site. I filed my report, I submitted my analysis, I handed over my documentation, and then on a Tuesday in October, my husband came home and told me he wanted to move on. The family court process in Ontario is specific and procedural and deeply unsexy, which is not what people expect when they imagine divorce. There is no dramatic reveal. There is no single moment where everything changes. There are forms. There are financial disclosure requirements. There are deadlines. My husband's lawyer filed a motion asserting that the joint investment account should be divided based on equal contribution, which would have been straightforward if equal contribution were actually what had happened. The account had been opened jointly, but I had managed it. I had made the allocation decisions. I had rebalanced it quarterly. I had moved funds in 2022 based on analysis I had done on my own time, which had resulted in a return that was significantly above the market average that year. His position was that it was a marital asset and should be split 50-50. My position was more nuanced, and I had documentation. The morning of the first court date, I took the train downtown. I had a coffee from the place on Spark Street, and I sat in one of the benches outside the courthouse for a few minutes before going in. It was late February, and there was still gray snow piled along the curb from the last storm, and the sky was the particular white that Ottawa skies get in winter, like a piece of paper that hasn't been written on yet. I thought about the backsplash tiles. I thought about the February I had spent on my knees on the kitchen floor, measuring grout lines, getting the spacing exactly right because I am the kind of person who cannot leave something imprecise when I know how to make it right. I went inside. His lawyer, his name was something polished and forgettable, looked at me across the courtroom with the particular expression that some people reserve for those they have already categorized. He had categorized me. I could see it. He had looked at the other side of the aisle, seen a woman in her early 30s with a folder and no counsel listed on the file, and made a decision about what that meant. My husband leaned over and said something to him again, and they both glanced at me, and his lawyer had the decency to look at his papers instead of at my face. The judge was a woman named Justice Osei-Mensah. She had been on the bench for 11 years. I had looked her up. She had a background in complex civil litigation before her appointment and was known, according to several people who had appeared before her, for not suffering imprecision. She called the matter to order. His lawyer stood up and began to outline their position. He was good. I will say that. He had a confident cadence and he presented the asset division framework cleanly and he made it sound very reasonable. The idea that everything should simply be split down the middle. When it was my turn, I stood up. His lawyer glanced at my husband with an expression that clearly said, "This will be fast." "Your Honor," I said, "I am appearing without counsel today. I want to know for the record that I am a certified forensic accountant and I am familiar with financial documentation and evidentiary standards. I'll try not to waste the court's time." Justice Osei-Mensah looked at me over her glasses. "I appreciate that," she said. Her voice was dry and very precise. "Please proceed." I had prepared a binder. Tabs, numbered sequentially, a summary sheet at the front, the kind of thing I would prepare for any file, which is to say, exactly the kind of thing you need when you are standing in front of a judge and the other side has a Bay Street lawyer, and you have yourself and 4 years of careful attention. I walked through the account history, the opening balance, the allocation decisions, and the dates I had made them, the market comparisons, the returns. I submitted documentation showing, month by month, who had accessed the account management portal, who had placed the trades, who had rebalanced the holdings. His lawyer objected twice. Both objections were addressed in the documentation I had already provided. Justice of Samansaw asked me 2 questions. I answered both of them precisely and cited the relevant provisions of the Family Law Act. At one point, she looked at his lawyer, not unkindly, but with the particular look that a person gives when they want an answer to something and they expect it to be a good one. "Counsel," she said, "your position on equalization presupposes equal contribution. Miss, she said my name has submitted documentation that appears to speak directly to the question of contribution and management. What is your client's response to Exhibits 4 through 11? His lawyer paused. It was a very small pause. "You would have missed it if you were paying attention. We would argue, Your Honor, that management decisions within a joint account do not constitute a separate contribution under the Family Law Act, and I'll review the documentation," she said. "We'll take a brief recess." My husband found me in the hallway during the recess. He was alone. His lawyer had stepped away to make a call. He looked different than he had in October. Smaller somehow. Not physically, just the way a person looks when a situation has not gone the way they expected and they're recalculating. "I didn't know you were going to do this," he said. "You didn't ask," I said. "You should have just gotten a lawyer. It would have been simpler." "Simpler for whom?" He didn't answer that. "Simpler for whom?" He didn't answer that. I looked at him for a moment. This person I had lived with, bought a house with, caulked baseboards with on a Sunday while he watched hockey in the other room, and I felt something settle in my chest. Not anger, not satisfaction, something quieter. The feeling of a number that finally resolves. "I'm going back in," I said. "I should tell you the other thing. The thing that was not part of the family court proceedings at all, but that happened the same week. The file I had worked on in the fall, the Harwick Development Group file, had been passed to the relevant authorities in November. I had submitted my analysis and then, because that is the extent of my professional involvement in such matters, I had moved on to other work. In the second week of February, 3 weeks before that first court date, I got a call from the legal counsel who had retained me. They wanted to confirm some details of my methodology. Standard follow-up. I answered their questions and thanked them and hung up. The following week, there was news. A small item in the business section, the kind of thing most people skip over. A local development company under investigation by the CRA and the Ontario Securities Commission for financial irregularities. Employees placed on administrative leave pending the outcome. My husband had been placed on administrative leave. He had not told me. I found out because my mother called me. She still reads the physical newspaper, one of her habits I have always found charming, and she said carefully, "I saw something about Harwick in the paper today. Isn't that where—" "Yes," I said, "I know." There was a long pause. "Are you okay?" she said. "I'm fine, Mom," I said. "I'm actually very fine." What happened in the courtroom that morning, in the end, was not dramatic. There was no gallery of people watching. There was no moment where someone gasped. It was just a courtroom in February, with fluorescent lights and a judge who paid attention to documentation. Justice Osei Mensah did not rule that day. She reserved her decision, as judges do. But she said something before she rose. She looked at both sides of the aisle. She said that the financial documentation submitted was among the more comprehensive she had reviewed in a matter of this nature. She said that the question of contribution and joint asset management was exactly the kind of question that the Act was designed to address, and that she would be reviewing the exhibits carefully. She looked, briefly, at his lawyer. Then she gathered her papers and stood, and everyone stood, and she left. His lawyer turned to my husband and said something in a low voice. My husband had gone very still. He was looking at the exhibit binders on my side of the table, all 11 tabs, all the color-coded dividers, all the months of account statements that I had organized the way I organize everything, which is carefully and completely and without leaving anything to chance. I picked up my folder. I buttoned my coat. I walked down the center aisle of that courtroom and out through the heavy doors into the hallway, where the fluorescent light was just as flat, and where everything was exactly as it had been when I arrived. Except that it wasn't. Not really. The ruling came 6 weeks later. 23 pages. Justice Ose Mensah found in my favor on the question of investment management contribution, citing specifically the documented pattern of sole management activity and the resulting above-market returns as evidence of unequal contribution requiring adjustment in the equalization calculation. My husband's lawyer filed a request for review. It was denied. The house with the hardwood floors and the backyard sun and the kitchen backsplash I had tiled myself on a Saturday in February, stayed with me. The equalization payment reflected the court's findings on the account. By April, I had started regrouting the bathroom upstairs. It's the original hexagonal tile, the tiny white kind, and some of the grout had gone gray and crumbly near the window. I work on it in the evenings when the light is still good. I measure carefully. I make sure the spacing is right. I'm the kind of person who cannot leave something imprecise when I know how to make it right. Some things don't change. I've decided that's not a flaw.